Hello, my culminating friends. Thanks for joining us today. Our guest is Ashley Baker. Ashley Baker has sort of the job that I probably would think that I should have if I weren't having this job. She's the Director of Public Policy for the Committee for Justice. I've thrown up here your Committee for Justice page, Ashley. Look at all the stuff. Look at all the stuff. Supreme Court, technology, regulatory policy, judicial nominations, intersection of the courts, regulation, and technology. Gosh, I mean, if anyone follows anything I've had to say or write in the last couple of decades, actually, that's, this basically, it'd probably be more appropriate to say that Ashley should be hosting this podcast, but she's too busy. She's too busy. She's doing all the things. I hope you haven't been too busy I hope you've been too busy to get COVID. Everyone I talk to is getting COVID again or getting it for the first time. You're right. You're good.
I had it last month for the second time. Not
last month for the second time. Yeah. Man, it's like I can't get away from you people. Well, I guess I can't because I'm wearing a mask around my microphone. We know that that's overly all you need to do.
Right.
Ashley,
to get sick.
So tell me about the Committee for Justice. I mean, it's a pretty generic name. It's amazing to me that you were able to grab it, or your predecessors were. What is the Committee for Justice focus on?
Hey, well, first, thanks for having me here, Ron.
My pleasure.
So the Committee for Justice. Since we were started in 2002, so they were able to grab the name then. Now there's a Committee for Justice for everything. People often ask me, is there a committee against justice? And I say, well, that's the Department of Justice. So there's also that. And
enough.
What we do is we work on a lot of issues related to the Supreme Court. We originally were started to work on judicial nominations during the time of the obstruction of President Bush's federal court nominees in 2002, and kind of grew from there to cover a lot of issues of constitutional law that are particularly relevant to conservatives, and that includes like the administrative state particularly. I started my job at CFJ, which you're welcome to have for a while, by the way, if you really want it. We can switch for a while. I started it in January 2017, so I've been there since then, and I work on an array of issues, including like nominations, Supreme Court, the administrative state, antitrust, and those are all kind of pretty relevant right now. So it's like everything, colliding at once.
Well, you say it's pretty relevant right now. So I'm going to actually go to this before I ask you the next question, which is, I see from your signature block that of all the things you're doing and all the places you're doing them, that you're also involved with the Alliance on Antitrust. And you are actually, this is an organization which is a bunch of organizations.
It's a project of mine that's part of the Committee for Justice. It's not a separate organization.
Understood. Okay, so that means you don't have another separate phone number or desk.
No.
But you have a, so you say all things that are relevant, but it seems that the Antitrust Division doesn't think it's relevant to anything. When I was in law school back during the Stone Age, I took antitrust. I took advanced antitrust. I was an economics major, so those things interested me a lot. And then there was no antitrust. There has been so little antitrust enforcement from the federal government for the last generation that you'd think that there had actually been a statutory change of some kind, but there hasn't been, has there?
No, there hasn't been, and there being no action in the sense of it not being in the media, being boring. That was more fun. The Trump administration, by the way, there was more antitrust enforcement in the Trump administration at the FTC than the Biden administration. Ironically, they're talking a lot of hard talk about it right now, but really they're just knocking down guardrails and trying to pass rules and regulations in the future that are going to be pretty broad. But yet they haven't really filed any successful claims. I think that's kind of a problem. It's not to say that there's been nothing. Sometimes they've brought the wrong suits, but yeah, you're right that we could do a better job overall in that area and focusing more on enforcement and less on things such as Lena Khan's pet projects regarding pretty much everything else would be preferable there.
So what's an example of the kind of pet projects that you're referring to?
Oh gosh, a lot of them, starting out, a lot of them are procedural. So the FTC didn't have a majority for quite a while here recently. They just regained that, but this time, particularly this time last year, is particularly busy. And a lot
Wait,
of
explain to listeners what it means when you say that the FTC didn't have a majority.
There was one vacancy for commissioner. There is a 2-2 commission, so you need 3-2 to pass a lot of the things that are more partisan, more or less. Because it's a bipartisan commission. We have 2 Republican commissioners sitting on the commission right now. Now we have 3 Democrats. One of them was recently confirmed. But over the course of last summer, for example, there were a lot of procedural changes that, long story short, would make things a lot easier to engage in unfair methods of competition rulemaking, which is a pretty
rulemaking, not easier to engage in unfair competition. That would be bad.
Yeah, they've certainly started moving in that general direction.
The direction of making rulemaking
yes,
easier to do. And so that's sort of a bipartisan effort.
That's not a bipartisan effort, I would say. No, those were all 3-2 votes last summer. The procedural ones that I was referring to, but historically the FTC, and if you took antitrust, you would recall this probably even at the time then, they've been kind of knocked into place by Congress a couple of times by getting out of hand and regulating things like sugar and breakfast cereals and making a lot of rules that they don't have the statutory authority to do so. And for a while, they're able to kind of restrain themselves whenever, every couple of decades, Congress says, no, you can't do that according to the statute, or the Supreme Court says that. And then they, rein in a bit. And then now, we see that expansion back to the 70s, more or less.
So what is the conservative point of view, the post, to some extent, we conservatives, and you don't get blamed because you're young enough. We conservatives got us here by the promotion of the law and economics movement in the 80s, the Supreme Court, and stop me if at any point you think I'm misstating what for me is a recollection, but for you as a professional, stuff you really have to know. But we had this tremendous law and economics movement that came out of Chicago, but primarily, and we had a very receptive Supreme Court, Reagan appointees in particular, who were open to this idea that what had traditionally been considered to be anti-competitive practices should be considered in terms of their overall economic efficiency and not only economic efficiency and benefit to the consumer as measured by microeconomic metrics were factors that had not probably been considered sufficiently in the heyday of antitrust enforcement, 50s, 60s, early 70s, should be considered more in the, going forward, as a result of which very little antitrust enforcement started happening during Republican administrations.
So I'd make some modifications to that
Please.
Historical summary, which is essentially, so let's start a bit further back in let's say the 1960s. The text of the Sherman Act is really vague. So over the years, it was, what is an unfair, restraint in competition? Everything is a contract and restraint of trade. That's what contracts are. So how do we define this? How do courts interpret this? Because Congress was, very vague, and it developed in a way almost that common law does. Throughout the years, throughout judicial opinions, but it was there was no guardrails. It was it was in the 60s, there's this Justice Potter Stewart said it's the only sort of consistency in antitrust law is the government always wins, which I think is a pretty good way of summing it up. And then what the Chicago school did primarily, though, is it gave it some sort of guardrail, some sort of purpose. And you said price effects, or I don't recall exactly the term you used, but the consumer welfare standard is more than just price. It's more about the competitive process rather than, and it's not about competitors either. And that's, a key distinction. You don't protect competitors because, I mean, that's against the nature of competition, right? Which is
Right,
what
and
Europe is trying to do.
every single defendant's antitrust brief in the history of mankind has always said that the purpose of the antitrust laws is not to protect competitors, but to protect competition. I mean, that's I don't know, I don't know why people, and we don't not, but we always feel obligated to include that line in there, and we do.
Right. Well, it's a big technical distinction too. What makes us different from the EU and Canada. So
explain that, because people who follow this stuff in the news, which is probably not a ton of people, will notice that I don't really notice hardly anything about Canada until fairly recently, but in the EU, certainly, they're much less shy about being aggressive on antitrust, including with respect to a lot of companies that are basically untouchable in the United States, like Facebook.
well, I mean, one thing you'll notice about those companies and their method of enforcement is they're enforcing it against U.S. companies. And you have a long history of, the European Union failing to innovate. And I would say that's because of a variety of factors, but overall, a big part of that is because of their regulatory system and that deterring venture capital back to the United States. So part of why they regulate companies the way they do is also a protectionist move on their own. But if you look at privacy law and GDPR and all of those areas, you see a much more restrictive environment more generally. Than you do in the US. And now, like, some people in the US are kind of getting those ideas that they have in the EU, and those ideas have not served them very well in the European Union. There's a reason why there are few tech companies in Europe.
You think they have not served them well?
No, I don't think so. And there's data to back that up too, not specifically as much in the antitrust context, because that would be harder to evaluate. But looking at privacy law, for example, even pre-GDPR, if you go back to like the European Privacy Directive of 2002, there are studies, and I forget who was the author of this study, but essentially that tracks the draining of venture capital out of Europe following the development of certain European privacy laws. And if it really affects the way they do business, especially innovative companies, and don't allow them to grow whatsoever, then venture capital moves to a more favorable environment.
All right, but I mean, couldn't we just as well frame it as the Europeans have made it harder to exploit consumer privacy and data, so they've gone to a more libertarian or lower regulatory regime in the United States where it's easier to abuse or exploit, depending on how you want to look at it, consumer privacy and data. I mean, you wouldn't argue, would you, that the existing regime with respect to regulation of the big tech companies is satisfactory in the United States, would you?
No, there are a lot of ways in which it needs updating. I would say the key difference, though, is just fundamentally in Europe, for example, they look at privacy as a human right. And
yeah, it's almost a fetish.
Protection of data. Yeah, and that's not the same thing as privacy. Protection of data, they mean each and every kind of data point online, and they view corporate power overall a bit differently than we do. Like in Germany, for example, antitrust laws are kind of shaped to protect the state actually against companies.
So that's an important point. In other words, I posited probably a false or an implied false dichotomy, which was that corporations versus consumers. Well, no, there's at least one other major player, which is the state. Now, however, what we have in the United States is convergence of corporations and the state in a way that, to a large extent, was probably already the case in Europe, but is certainly explicitly the case right now. I want to talk about that, but first I want to actually, I got a little bit off track because I wanted to get the background down, and I thank you for tweaking it. What is the concern, given where we've come and where we've been in the last 20, 25 years on antitrust, to a large extent because of the Chicago schools' influence? What is the modern conservative take, from your point of view, on regulation and antitrust? How is it? Has it changed, or have we just misapplied it?
I think to some extent, I mean, I think you're kind of separating those two things into, this sort of like market fundamentalism or even like tech, exceptionalism, like any law that like helps promote, technology is good. And I don't personally prescribe to that line of thinking, but I also think, you just talked about corporate power versus, this power of the state. And I do think in a certain way that those definitions of which one is more important, which one's a bigger threat, that's evolving. But that is true because I mean the most dangerous thing is a combination of the two. If you have the government able to coerce corporations, and a lot of the bills, like for example in Congress right now that are being put to like raid in big tech or whatever, that are Democrat bills, they would actually allow for a lot more of that. And if you have a regulator and threatening to investigate a company, it would be 15% of their revenue for this violation. You can get them to consent to pretty much anything. And that's kind of how some of this would work.
Okay.
It's hard to say what the modern conservative definition is, though, because there are people out there who redefine conservatism and say conservatism is what I say it is, who
of course
and it's just not the definition of anything conservative. So that's rebranding the term. The left is very good at that, by the way, just taking these terminologies and saying it's it means this. But I feel like that's what certain people are doing right now with conservatism in general. I think that's also moving the opposite direction.
Well, you're right. I think that there has been a battle for the soul and mind of conservatism. There have been many battles, of course, but I think the Trump era has really brought it home, and it resulted obviously in a tremendous shakeout. And to a large extent, people who for years described themselves as conservatives are now seen, I think, as not conservatives at all.
Some have drifted quite a bit, though.
Let's take a look, because I think that this, tell me, I mean, this is your project. The Alliance on Antitrust was established to address the increasing calls to move away from the consumer welfare standard and to use antitrust as a political tool. So that is already, when you say address increasing calls to move away from the consumer welfare standard, I assume you would argue that no, Ron, the consumer welfare standard is actually the appropriate standard, but we're not necessarily. Let's look at the second sentence. We believe.
So to talk about those calls for a second, though, I mean, people like Elizabeth Warren, for example, Bernie Sanders, they're the ones explicitly saying, let's move away from this, because, like I said, via the 1960s and the text of the Sherman Act before the consumer welfare standard, you can weaponize it for anything. Now, to kind of an analogy, other areas of law, particularly like civil litigation or let's say like environmental suits, for example, they're all over the place. I mean, they've really managed to weaponize certain areas of law for different purposes, whether that be the environment or any other thing that can just micromanage different areas of the economy. And it's very easy to do that with this area of law. So that's what I mean by weaponize. Sorry to get you a bit off track there.
No, I know. Well, no, I think that's exactly right. But I mean, so there is an argument that I'm sure that you're familiar with, which goes along the lines of we conservatives are losing the culture war. We're losing the political war, or at least some very, very important battles in the political war. Antitrust could solve many of the problems resulting from the domination of, let's say, platforms such as Facebook and Google. And it's not, we ought to weaponize it in order to move the needle back in the direction politically that benefits conservatives and benefits what we think are the fundamental values that conservatives share and that most Americans actually share. I really set up a big softball for you. What's your response to that?
Sure. So I would make a practical argument against that, and that it's just, kind of foolish to think that we would win that fight. The other side has decades of experience in weaponizing the bureaucracy and litigation, and that would certainly swing in the other direction. However, when it comes to, some of the broader issues you're talking about, you're right, those are issues, but antitrust law wasn't designed to address speech. And there are a lot of other areas of law that could be modified, could be better enforced. There are speech laws, there's Section 230, there's intellectual property rights enforcement. That's a big one that you don't see those people talking about. And for those of us with any expertise on the subject, that's kind of notably absent too. There's an entire area of existing law that's not really being that strongly enforced against companies that just never really is mentioned in these conversations. But there are a lot of other solutions, and I feel like they've viewed antitrust as being kind of a vague but easy tool. Statutes are hard to amend. It used to be, we need to use Section 230, and then no one came up with a proposal that had any teeth really. And then it's moved from debate to debate to debate, and it's like from my perspective, I've seen it kind of coming this way for a while. I'm thinking, when are they going to just say, oh, antitrust? That happens, and that's happened on both sides like several times throughout history. There's been kind of this populist antitrust movement kind of going in both directions. Had Ralph Nader, for example, was champion of it at one point in history.
I'm sorry.
I said Ralph Nader was a champion of political antitrust at one point in history. The problem is, though, when you have these people on both sides right now saying we want to weaponize antitrust for different reasons, and they all have different problems that they want to solve. If you ask them, to identify the problem, they're all going to give you a different answer, and that's really problematic because it can't be a jack of all trades. It is not going to solve those problems, and some of the problems are actually at indirect tension with each other.
So the consumer welfare standard how is the consumer welfare standard affected by the existence of, let's say, let's stipulate for me that Google, that notwithstanding that numerous judges have found to the contrary, those of us who know the internet, those of us who use the internet know there's one search engine. It's Google. Of course, there are other search engines, but Google has fantastic power, and it manipulates search results for anti-competitive reasons. Now, those reasons, anti-competitive, not only ideologically, but prospectively, any kind of, in other words, the search results are not truly organic. So here's a prospective antitrust problem, right? You've got market domination, you've got extraordinary obstacles to market entry, you've got extraordinary network effects, which the courts haven't really caught up to yet, but which in technology are the name of the game. It's essentially the modern day equivalent of vertical integration. Why shouldn't we be looking at Google as a monopolist, at least just in search, or should we?
Well, in search, for example, first of all, I would start by saying that size alone isn't the problem, and that's always been the case, and that does lead us down a bad road. So it's moving to what actions they've taken, and I use the word if search results aren't truly organic. I don't know what that would look like. I was just thinking, you wouldn't want them to be entirely random. But it depends on what they were doing to restrict competition. And there are a lot of lawsuits across the country right now looking into that. And they're still kind of mid-discovery. I don't know what will become of those. It really depends. And I wouldn't agree necessarily with the vertical integration analogy either. Vertical integration's often been used for some very practical reasons, such as in manufacturing, or such as in the Federal Trade Commission actually has a case right now against a cancer screening blood testing company right now. And essentially essentially what they do, and this is a common model like within the pharmaceutical industry, is there's the larger company, and the name of that company is Illumina, and they run all the machinery and everything that does the testing. And they'll like spin off a kind of research arm. So they're developing this project. It doesn't make any sense to have, various teams of researchers in-house developing their own project. So whenever it becomes viable, they maintain 20 or 25% or whatever the threshold is of that small company. If the product seems viable, then they reacquire it because that makes a lot more sense from just a business perspective. So they stopped that, and that product actually hasn't been on the market yet. So you can't really say this hinders competition because there's no competition out there yet because the product doesn't exist. There's a potential competitor maybe in China. That's the one potential competitor, but that's I think an example of misguided antitrust enforcement where vertical integration is a good thing. Okay,
so given that vertical integration is not the existence of vertical integration doesn't turn a prospective antitrust violation into a per se case. I'm not suggesting that. I'm just saying network effects are a real obstacle to obstacle to competition. If I could prove to you the things that I listed, which is that, in fact, a better example that I'm aware of is Facebook. Mm-hmm. Or Amazon for that. Amazon is doing things now, and has been for the last 10 years, where it, besides becoming to a large extent the exclusive place to buy things in a way, but in a way that Wells Fargo might have been 150 years ago, and that the world didn't come to an end there. There were competitive options did develop. But everyone has to get onto Amazon in order to compete. That's pretty, in other words, everyone who's selling is selling on Amazon. Mm-hmm. Amazon then offers opportunities to do house brands. You can become an Amazon, you can help Amazon develop a brand in your, in what it is that you sell, let's say spices. And then so that you produce a line of spices for Amazon, and you have a contract for 2 years. And after 2 years, they don't guarantee you anything. You get the benefit of the 2 years of sales because they've been selling and promoting their stuff. And first of all, they're now selling a product that is competing with their own customers. In other words, all the other people who sell spices on Amazon. And then after 2 years, they may or may not, at their discretion, renew this relationship, or they may just take all the know-how and channel building that you've done for them for 2 years, take over the business, and leave you with nothing except for the 2 years worth of profit. Is that the sort of thing that consumer welfare? I mean, I guess the point would have to be you'd have to demonstrate an effect on the fact that all that happened is really interesting, Ron. But are consumers being left with fewer buying options, or is there a price effect? Those are the things you'd have to look at, right?
Well, I would disagree with the way in general you're framing the consumer welfare standard, and that antitrust law, antitrust violations are still what they are. It just guides them into not being about other things. That's just a much broader way of framing the question of what is this area of law for. And that could be it depends on what claim you're making, whether it's under antitrust law, which would have to be tied to a specific action they took. It's hard to deal in the hypotheticals in antitrust law.
In other words, is it monopolization, or
what you were describing sounded more like a trade secret violation or a copyright problem.
Yeah, but it is. No, it's not, because what would happen is you would. I think it'll get you. I think my hypothetical will get us off track. But I think there is something that anyone who's ever shopped on Amazon realizes now, which is Amazon does compete with its own customers. So you've got products A, B, C, and D from cables from
CVS
A, B, C, and D.
Too. Walmart does. All store brands do.
All store brands do. but and that, in other words, that in and of itself isn't necessarily of interest.
It's really
Because
hard to like,
it's
pin down, hypotheticals in this with.
so is there anything? So is there anything in when I talk about Amazon and Google and Facebook and Twitter, is there anything those companies are doing that you think are a proper focus for antitrust enforcement?
Sure. I mean, there certainly could be. And I don't want to make predictions too, because a lot of these involve, specific lawsuits that are going on right now regarding like the advertising industry, for example, and those are in the discovery process, and things are still coming out there, and I haven't seen all the documents of them going through.
No, I'm not asking you to focus.
But I mean, there could be, and it's certainly worthy of investigation. But saying something's deemed worthy of an antitrust investigation, saying that there was an antitrust harm, there's a lot to get from A to B there in terms of just internal investigations and document production.
Okay, but I mean,
there could be. I mean, maybe,
there could be. But I mean, is like, what's an example of the? So I mean, I think it's very telling that you said there's no antitrust isn't meant to deal with the problem of speech. In other words, with the problem of corporate censorship.
Right.
I mean, as you pointed out, there's nothing. I
think this is getting pretty off track in hypotheticals, though. I mean, it's just really,
okay.
Hard to, go there. Just because, well, it's just not how antitrust specifically works without having, that specific action to pin it to, which is them, taking certain internal. It doesn't, never really plays out well.
It never plays out well.
In terms of, computing on your end and my end in terms of, what would what exactly is the action that led to the claim? All of the, I mean, in every, of these scenarios, there could be an antitrust violation, hypothetically. I mean, not in necessarily that specific one. I mean, you'd have to elaborate on specifically, what it did to get to that position, like the nature of the contracts, and then it just kind of, goes off the rails.
Let me ask you then one last question on antitrust, which is, I've made the observation that when there's very little antitrust enforcement from the government, judges in civil cases are much less enthusiastic about antitrust claims on the private side. Would you agree?
That's, I would say there's some degree of truth to that. And if we could talk maybe for a minute about what the left is trying to do and Democrats are doing regarding antitrust.
Yes, I would very much like to hear about that, but sure.
Sure. So, I mean, there's a debate in Congress, for example, and there are a lot of, I mean, you've probably seen antitrust in the news a lot, both in the agencies and the cases in Congress. But like right now, one of the primary bills that are being considered by the Senate, and this started on the House side last summer. This came from David Cicilline's office, was kind of his pet project. This was a bill drafted by the House impeachment manager. I think it's fair to say that it's not meant to protect conservative speech, although some conservatives are making that claim, which to me is extremely bizarre, and nothing in its text. It's kind of a pass it and see what it does sort of bill. Several of these are, but we have two groups of Democrats right now arguing, saying, well, the current draft of the bill does not, would preclude basically the moderation of like hate speech and misinformation or disinformation or whatever you want to call it. And then another group saying, oh, well, no, you can do that perfectly well under the current text, which is also equally concerning if they think that it's amorphous enough and that there's that both sides though want to use it for that purpose, and that's not, for example, that's not a competition concern. And then you have Republicans saying, well, we want to use it for things that make a lot more sense, or the basic purpose of using it to protect competition. But when you have like 5 different reasons for using this, and the bill's really badly drafted, and gives the FTC and the DOJ a lot of joint power to coerce companies, for example, based on certain enforcements. And also there are things in some of these bills too. I'm sorry if I'm getting off track here. This is a broader problem. shifting the burden of proof away from the defendant into the government. And more broadly, I mean, I think that's something that we should just outright reject, regardless of who's on the other side of this. And if you look on the flip side too, on what are Democrats saying when it comes to antitrust and judges, by the way, you see there's a kind of a direct overlap in those who are on the kind of neo-Brandeisian left who want to use antitrust for a lot of other purposes and want an expanded regulatory state. You also see them calling for some very, very liberal judges. And it was, they were very happy when Breyer retired, said, anyone but Breyer would be great, but they have to rule against corporations every time. And as much as, you don't like corporations, it's not the role of a judge to decide based on the type of the party that they're ruling against. And I think that's a big problem. That's very revealing that you see always that direct overlap there too. So any of those like reflexive judicial activist judges obviously have not served us very well on the right.
So, I mean, I think you make an important point, which is that it's almost as if these Democratic legislators are looking at antitrust as the agency we haven't yet adequately used as a tool to hammer all kinds of conduct the way we have the CDC. And
yeah, and it wouldn't even be fair to call some of these bills antitrust bills, really, in the traditional sense. I mean, it's really just broad regulations, and it gives agencies a lot of authority and a lot of discretion to decide on how to enforce this or whether to enforce it in the future. And that's itself. I mean, we don't want the Merrick Garland DOJ and the Lena Khan FTC teaming up to decide what applies to our companies and what does not.
I think you're, to the extent that we're talking about any kind of expansion of statutory authority to regulate,
right,
that just can't go well now. I mean, government, I don't think anyone can seriously, question the fact that the administrative state is absolutely compromised. And if there's any single agency that has lost moral authority, it's the Department of Justice. And if only because it's doing the same thing everyone else is doing, but it's doing so with its unusually, acute coercive power that this administration has already tried to give to OSHA, in which it needed the Supreme Court to tell it couldn't do, which really all you have to do is read the statute to know that. I mean, they will do whatever I think you'll find this interesting because I wrote an article suggesting that under the Federal Trade Act, anti-competitive conduct by online platforms, by social media platforms, should, if not anti-competitive, deceptive conduct. In other words, a consumer deception is already something that the FTC could address. It doesn't need, because as you say, the antitrust statutes that were passed during the progressive era, which is, we're talking 100 years ago, are written very, very broadly. And it is interesting to me that these bureaucracies have not already been weaponized to the extent that you would think that they might have been. And given, for example, how resistant they were to the Trump administration, they haven't really come out swinging on behalf of the Biden administration either. Is this actually the case of the sort of administrative state stability that some people argue is actually a good thing?
Well, it depends on which agency you're talking about right now. Like I said, there's some that have not had a majority on the commission. You have this administration too has moved really slow when it comes to executive appointments. So things are about to get really bad, probably the CFPB, for example. And I think the CFPB is an example of something that was weaponized to a very full extent under the Obama administration. Yes, so it was certainly it was pared back a bit.
Explain what you're talking about. Which agency this is?
the CFPB, which is created during the Obama administration, has a massive amount of authority, and it has a massive amount of penalty, or had a massive amount of penalty authority. There have been some cases since then that have kind of like moved into the direction, but it's basically untouchable too by the president. I mean, you do have a broader issue too here though of presidential removal power at both agencies, actually, that's you see being addressed through the courts. That's going to be pretty interesting coming up. I don't want to get off on a tangent on that, but there's some interesting cases regarding that. You have an agency that's pretty much completely unaccountable, and it has a really, really broad regulatory mandate. Under the Trump administration, they didn't do as much, and there's also a lot of overlapping, authority between other agencies. I mean, it's never usually necessary to create another agency, and you certainly can't make it go away very easily once you do. And the CFPB is an example of that. And then you see in the Biden administration, there's now recently a head of the CFPB he was only nominated recently, but he was at the FTC. Actually, he's continuing to vote at the FTC while in charge of the CFPB by just dumping a lot of votes on his last day there that came out over the course of like 2 months, which is certainly questionable and probably challengeable. You had, I like to make the analogy, Judge Reinhardt on the Ninth Circuit passed away, and the opinion came out, I'm not sure if you remember, after he died, the Supreme Court, remanded the case and said, no, you're not appointed for eternity. And we have here someone who wouldn't leave the agencies either. So I'm not sure about exactly the legality of that. We see a lot of abusive processing. I think it's hard to compare what's going on at other agencies to like DOJ, for example. I think you make a good point there. And looking at Merrick Garland and the investigation of like parents, for example, and those sorts of issues, and those are really, I think, a lot more concerning overall in terms of using the power of the state to do something, but also the DOJ has had ample opportunity to do so over the past year and a half, or however long it's been. Yeah, a year and a half.
And I think to a large extent, your argument about the last thing we need, almost regardless of who we is, unless you mean the very thin crust of people who control the Democratic Party and its finances, the last thing we need is to officially give any more power to any government agency, because it has so readily demonstrated its amenability to abuse. I mean, I guess that would be something that all the members of the Alliance on Antitrust probably would believe in common. Do you do any legislative handicapping? Do you think this bill is going to make it? The Klobuchar bill?
I don't think there's nearly enough support. No.
That's a relief.
Okay, yeah. I think at one point it was being sent to the media. Also, Hillary Clinton endorsed it. So if it's not dead already, it's going to die now.
Wow, that's a new kind of Clinton aside that we hadn't even considered.
Right.
Ashley, I'm sorry that I spent so much time trying to beat you up on antitrust, but I think I've come away with a much better understanding of your point of view. I mean, I do think there are serious anti-competitive concerns with regard to the big tech companies. And your point there is that, well, you need to identify the specifics. You need to identify how those specifics line up with the applicable law on anti-competitive conduct, and then apply the consumer. Ron, if what you say is a problem, the way you say it's a problem, you need to demonstrate. You should not have difficulty demonstrating a negative effect on consumer welfare.
Right. I would add to that, though. I wouldn't say that no changes are needed whatsoever to the area. I mean, there are changes that can make enforcement easier. Like, for example, DOJ and FTC have overlapping enforcement authority in a way that doesn't make a whole lot of sense.
And that's been true for what, 50 years at least, right?
Right. I know. There have been several proposals. Mike Lee's had a few to kind of help consolidate that. His would consolidate under one agency. I mean, I think streamlining that authority, you don't have to necessarily consolidate it under one agency or the other, but there are a lot of ways in which you can make improvements there and make enforcement a lot easier. There are a lot of things that you can do, and these aren't the things that capture much media attention either, though, when it comes to antitrust, because they're mostly procedural. But I do think there are ways to streamline the process and make enforcement easier.
Thank you very much, Ashley, for all the time you spent with me on discussing these issues. You seem to really have your hands full. You're in the mix really with all the issues that are affecting people, and I hope we have a chance to talk again soon.
Sure, great. Thank you for having me.
My pleasure.